Are we on the record?
Yes, Your Honor.
Good afternoon. Today is January the 21st of 2025, and this is the Lawrence County Municipal Court. I'm Judge David Landefeld. I'm a retired judge sitting by assignment of the Ohio Supreme Court, and this is the matter of the State of Ohio versus Philip Cook, and it's case CRB 24781. You're Mr. Cook, is that correct, sir?
Yep.
And Mr. Cook, you are represented here today by Attorney Morford, is that correct?
It is, Your Honor.
Very well. And we're here today, I believe, on a pretrial in this matter. I note for the record that there was a demand for discovery filed on December 31st of last year. Has that been complied with?
We have provided an answer, Your Honor.
Very well.
Judge, we are missing the video.
A video of?
The judge ordered the video from the date this occurred to be preserved.
And has that video been preserved?
Yes, Your Honor.
And Mr. Heald, can you provide that?
Absolutely, we can. I was just telling my assistant here that the copy she made for me, I misplaced it, so we'll be making new copies.
All right. How soon can you provide that?
Soon. I mean,
By the end of the week, maybe?
yes, for sure.
Okay. All right. Is there a request for, I don't see a filed request for reciprocal discovery. Are you intending to file that?
We do that on,
Okay.
sorry, Judge, you're
No, that's
addressing me.
fine. I'm in Rome. Let's do it as the Romans do it, okay?
I'm sorry. I'll let Phil address that.
Okay. So, as far as, the only thing that is missing right now would be the video of the incident that allegedly occurred on December 9th, is that correct?
Yes, Judge.
Okay. All right. Have there been any discussions of disposition in this matter?
Judge, may I have a moment with my
Absolutely.
client? Do you want to phone me?
Judge, I'd like to ask a couple questions, if I may.
Sure.
Do I need to stand while I do so?
No.
Okay. I'm going to be filing for some additional discovery based on some things that were, well, I'm going to be filing for some additional discovery. Also, I have a concern about, number one, Mr. Morford's been injured here recently. He's had numerous falls. Plus, I've got some concerns regarding his relative expertise in issues controlling in this matter. And I was wondering what the process would be of me obtaining new counsel.
Well, Mr. Morford is appointed to represent you, is that correct?
That's correct.
Well, Mr. Cook, there's no constitutional right for you to choose a court-appointed counsel, just so we're clear on that. I'd like to hear, Mr. Morford, are you having difficulties representing Mr. Cook in this matter?
Judge, I do not. I'm sitting here before you with 2 broken ribs, hyperextended knees, hamstrings, and quadriceps. One of the staff here came and got me to be here so that you wouldn't have to continue this. I have no injuries which would prevent me from giving Mr. Cook a zealous defense as I do each and every one of my clients, Judge.
Okay.
I've met with him several times with respect to the discovery that he wants. One of those matters is a video of the day back, I believe, in October of 2024.
No,
When was it?
no, it's a transcript.
When was your eviction.
August 1st, or October 1st.
He wanted me to ask, in this case, Judge, a transcript of his eviction hearing, and he also wanted me to ask for video around that time.
As well
I
as,
served let me talk.
my apologies.
I served a demand for discovery pursuant to the criminal rules, excuse me, Judge, pursuant to the criminal rules. And I gave Mr. Cook a copy of the criminal rules and showed him where, in my opinion, those two items were not discoverable. Thus, I did not ask for them.
And Mr. Cook, I take it, I'm not trying to insult you here, but you're not an attorney, correct?
No, I'm not, Judge, but
All right.
if I may,
Sure.
at the arraignment, which you were not present for,
Correct.
one of the statements made by prosecutor was that I had been coming here to harass court employees. In fact, that's not true, and prior to October 1st of last year, I had only been in this building once, and that was in 2021 to hand over evidence to the prosecutor's office in a different case. Between October 1st and December 9th, there were a great many things that transpired in this courthouse. And that all plays into what has culminated in my unlawful arrest here.
Okay. I hear what you're saying. I guess I'm concerned that you're somehow asking Mr. Morford to obtain something that really isn't relevant in this case. Is that what you were saying, Mr. Morford?
Absolutely, Judge.
Here's the thing, Mr. Cook. You have an attorney representing you. Follow his advice. That's the best advice I can give anyone. We don't, as I said, if you want to retain your own attorney, certainly you may do so. That's not something that the court would ever have a problem with. I'm sure at that juncture, Mr. Morford would withdraw his representation of you. But as far as this case is concerned, I don't know anything about the facts here. You know, I'm from Lancaster, Ohio. That's, you know, almost a 2.5-hour drive. So I don't. What goes on here doesn't really have a huge impact on my life. So just so you're aware of this, and discovery has been requested or demanded. Actually, it's been provided, except for the one video of December the 9th, I take it.
That's correct, Your Honor.
And I think when that is provided, then if you wish to discuss some disposition alternate to a trial in this matter, you may do so. Obviously, that's up to you. I don't see a request or a demand for a jury trial here at this juncture. Obviously, that's something that has to be requested within 10 days of trial. And I don't know if that's something you want. But all I can say here is take the advice of your attorney. He's got your best interest at heart, and I'm certain he wants to see the very best outcome he can for you. With that, Mr. Hill, if you will provide any additional discovery that has been demanded, that is in your possession, or that you have access to, that's relevant to this case, please provide it to Mr. Morford. I hope you can do that by the end of the week. What we'll do is we'll set this matter for a final pretrial then, and I am out of the state for the month of February, but I will be back. We can set it in March, and we'll try to get it off the docket as quickly as possible. If you like, we can set that final pretrial today and also set the trial date.
One thing we have to be aware of, Your Honor, is this is alleged to have occurred on December the 9th, which means that the speedy trial would become an issue in March. I think that there would be a tolling of time during which the Supreme Court appointed you to come, but I don't know how long that was, and I don't want to run into a time problem.
I'm trying to think when well, I was appointed, it looks like the certificate of assignment was December the 9th. I don't know when I got actual notice of it. I think it may have been that same day or a day after. So, if we set it for early March for trial,
March
I think
the,
we're within the 90 days at that point.
yeah, March the 9th, well, probably March the 7th to be safe.
March the 7th?
Would be the 90 days.
Okay, let me make sure. The fact that I'm out of state, I think would be, under 2945-71 would allow, or 72 would allow a reasonable continuance from there. But if we can do it March the 7th.
Mr. Gilbert, do you want to do that on a regular?
You want to do it
Monday or
March the
Friday
6th?
Docket or,
March the 7th? I don't care.
Judge,
What day of the week?
that's a Friday. And if there's
7th is a
normally-
Friday, 6th. I don't particularly want to do it on Ash Wednesday, the 5th. So,
Judge, can I throw a little iron in the fire?
pardon me?
May I throw a little iron in the fire?
Sure.
I ain't going to be filing a written demand for jury trial. He instructed me to do that just earlier today.
Okay. And what will that, when do you have jury trials?
I just need to have a couple of weeks notice, Your Honor, to get the jury impaneled.
So we could do it either the 6th or the 7th? Is that doable? Of March?
Let me make sure. Oh, stop.
Judge, either date is fine here.
Okay.
I would not be available on the 6th, but I could do it on the 7th.
Okay, well, March the 7th sounds like a plan to me. Does that work for everybody else?
It works here, Judge, and normally they start jury trials at noon.
With a 2.5-hour drive, that works for me too.
Good enough.
Okay, so. All right, let's review here. We'll have, Mr. Hill, you'll provide whatever additional discovery that's been demanded that you have in your possession or able to acquire. If there's any reciprocal discovery that Mr. Morford, you will provide that. And I'm trying to think when we could do a final pre-trial, and we can do this by telephone if that works for everybody on March the 3rd. Does that just make sure we have everything, and if there are jury instructions that special jury instructions that either of you wish to have, we can do that. Is there a time that's convenient for you on the
Is that a
3rd?
Monday? Well, Your Honor, that's a regular court day here, and we generally go to.
Well, how about the 4th?
4th's great. I could just about be available anytime.
Okay, so we'll make it a telephone, final pretrial by telephone. And we'll make it the 4th. Does 10 a.m. work for everybody?
We'll be in the middle of all one. It's Tuesday. That works fine, Judge.
Okay,
I'm sorry.
no, that's, I just want to make sure. And we'll make it a telephone conference. Okay. Is there anything further that we can do here today?
Your Honor, we haven't discussed a possible resolution to this. I don't know if they even want to
I'm
work on
always
that.
willing to entertain that.
As is the court. I mean, if there's a resolution that would be an alternative to a jury trial, obviously that's something the court would entertain. I'm not telling you what you have to, how you have to resolve it. That's between the two of you. Well, obviously, Mr. Cook is the guy that has to be involved. It's his right of liberty at stake. But having said that, whatever you folks may be willing to do to resolve it short of a jury trial, court that would certainly entertain and if reasonable, most likely would approve. So I throw that out there for you as well. And I don't know if you want to discuss today or if you want to just do that at some other time.
I'd be happy if we could go in the jury room and talk.
Okay. I won't participate in that, Mr. Cook. I have no desire, well, I may have a desire to do it, but I have no right to do it, and I have no reason to do it. So I'll let the attorneys talk. Certainly, Mr. Morford will consult with you if there's a potential resolution here, and we'll just go from there, all right?
Okay, Judge, could you give me the times again? We're going to do March 7th at 10?
March 7th at noon.
March 7th at noon.
Noon, okay.
And March the 4th at 10 will be a telephone conference for a final pretrial in this matter. As I said, I'm totally unavailable the month of February.
So the pretrial will be at 10?
Yes, sir.
Thank you, Judge.
Is there anything further that we can do here?
I don't believe so, Your Honor.
Not
Thank
from
you.
here, Judge.
All right, very well, then we're adjourned.